Good afternoon. My privilege as Dean to welcome everyone to our lecture this afternoon. Today's Brendan Brown lecture is a series that began in 1982. As some of you know, Brendan Brown was the 6th dean of our school and was an internationally recognized legal scholar. This lecture series invites outstanding professionals from various fields who have made a contribution to public life to share their perspectives on a wide variety of current topics. And on the back page of your program, you will see a listing of the speakers who've addressed us as part of the Brown Lecture Series in previous years. Our speaker today is Kenneth M. Feinberg. Mr. Feinberg has very modestly asked that I keep any words of introduction about him to a bare minimum. I will honor that request. So rather than detail for you his impressive credentials, I invite you simply to refer to the third page of our program for a description of his remarkable background and extensive experience. There you will learn more about his prominent role in some of the major issues of the past few decades, including relating to the 9/11 Victim Compensation Fund, the BP oil spill claims, and the TARP executive compensation, et cetera, et cetera. I would be remiss, however, if I did not share with you one personal thought about Mr. Feinberg. As I told Professor David Lipton when he arranged for Mr. Feinberg's appearance today, there have been enormous changes in litigation in the United States over the past few decades. I've been a witness to those changes. As a very high-profile lawyer, Mr. Feinberg has played what is nothing short of a transformative role in many of those changes, and his work has had a profound impact upon our legal system. Mr. Feinberg will speak today on the topic of unconventional responses to unique catastrophes, tailoring the law to meet the challenges. We are quite fortunate that he's willing to share his expertise and thoughts with us today. I can assure you, you will be most interested in what he has to say. Please join me in welcoming Ken Feinberg.
I want to thank the Dean for those comments. I just suffered coming over here today from downtown Washington a unique traffic catastrophe on Michigan Avenue that held me up by about a half an hour. I do apologize to everybody who might have been waiting. I want to thank the Dean. I want to thank David for impresario par excellence in setting this up and managing to have me make 2 appearances in one day here at the law school, which is a great thrill for me. And I can't tell you how honored I am to be part of the distinguished history of this law school and this Brown Lecture series. The Brown Lecture is well known in the Washington community, and I think probably the Brown Lecture series is well known nationally. And for me to be added to that list of prior Brown lecturers is really, it's a singular honor, and I am very, very honored and grateful to this great law school. Now, unconventional responses to unique catastrophes. Well, that's what I do. Every once in a while in this country, not often, every once in a while there is a tragedy. And that tragedy so triggers a public response of empathy, sympathy, anger, frustration, horror, that the American people rise up and decide we've got to do something for the victims. 13 days after 9/11, Congress passed a law. And the law simply said, anybody who would rather come into a unique compensation fund, grounded in tort, but a no-liability fund, an administrative fund. Anybody who would like to come into that fund and get paid as if they were in the tort system, and give up your right to sue the airlines, the World Trade Center, Boeing, the security guard companies, you know, a Massport, the Port Authority of New York and New Jersey. You don't have to. You can litigate. But if you'd rather come into sign up, subscribe to a unique compensation fund administered by one person, delegated authority from Congress to the Department of Justice to one person. You can do it. Up to you. 2 weeks after the BP oil spill in the Gulf of Mexico, the worst environmental disaster in American history, BP went into the White House for a visit. They came out of the White House after the visit. And they announced with the president, anybody who would rather come in to a no-fault compensation program administered by one person, delegated by us and the President of the United States. You don't have to. You can litigate in New Orleans. But if you'd rather come into a fund and waive your right to sue and be generously paid for all of your damages attributable to the spill, business interruption, lost profits, lost opportunity, damages, etc., you can do so. You can do so. 4 months ago, after blistering congressional hearings over the issue of GM's alleged cover-up of ignition switch failure in certain GM automobiles, GM announces anybody who would rather come into a no-fault compensation program and be compensated for damages, for death or injury arising out of crashes attributable to the ignition switch, can do so. You don't have to. You can litigate. But if you'd rather come into this fund, delegated to one person, the authority to design, administer, and decide, you can do so. Now, those 3 programs are rather unique, I must say. 9/11, BP, GM. They are true alternatives to the tort system. I'll take this money and I will give up my right to sue. Now, there are other first cousins to those programs that you're all familiar with. One Fund Boston, arising out of the Boston Marathon bombings a year and a half ago. Newtown, Connecticut, Sandy Hook Elementary School, arising out of the shooting of all those 25 first graders and teachers. The Virginia Tech shootings here in Blacksburg, Virginia, where a deranged student gunman walked into a classroom, killed 32 students and faculty, then took his own life. Aurora, Colorado, where a deranged gunman walks into a movie theater at the premiere of Dark Knight, kills 13, injures 200, sprays bullets. The Indiana State Fair, a couple of years ago, where a sudden windstorm, like a tornado, blew down the pavilion, killed 8, injured 15, 20 people. All of those tragedies result in another compensation fund, but very different. A first cousin, but not the same. All of those programs are not alternatives to the tort system. They are a gift. They're a gift. From private money from all over the country, people send in checks. We saw on TV, on cable news, we want to help these people. Here's money. Give it to the victims. Those programs where you set up compensation schemes, rather unique, but they're not alternatives to the tort system. You can take that money, turn around and sue if you want. So you got to make a distinction. You're all lawyers. You know the distinction. These three programs are alternatives to tort. All of these programs are charitable giving by the American people to be distributed to people who have been injured. And they can do what they want with that money. Now, all of these programs do have some commonality, of course. And I'll tell you one commonality. Never underestimate the charitable impulse of the American people. It is astounding to me. Astounding. In 2 months, One Fund Boston raised from private giving around the country $61 million. I've never heard of anything like this in my life. From 100,000 donors, 61 million. Virginia Tech, 8 million. Newtown, Connecticut, 8 million. Aurora, Colorado, 5 million. 9/11, 7.1 billion, all taxpayer money. The 9/11 fund stands alone in terms of the ultimate example of community support for certain victims. That bill, that law, did not appropriate one dime of money. It simply authorized whatever I need to pay these people, to pay it out of petty cash from the U.S. Treasury. $7.1 billion. BP paid it all in the Gulf. In 16 months, $6.5 billion. GM, we're now paying, GM's paying the freight. We'll see at the end of the program. Now, how does one react to these programs? All of them. I don't mind, not just the three that are alternatives to the tort system, but the other gift programs as well. What lessons do we learn? Well, that's very interesting. If you're a political science major, if your expertise is history and government and civics and political philosophy, I must say you have to question the wisdom of these programs. Take the 9/11 fund. The 9/11 fund was a unique response to an unprecedented national calamity rivaled only by the American Civil War, Pearl Harbor, the assassination of President Kennedy, and 9/11. Unprecedented. A national tragedy. And Congress responded with this law, paying victims taxpayer money, not private money. GM is paying it. BP paid that. Not 9/11. 9/11 was funded by the taxpayer, $7.1 billion. Now, I think the 9/11 fund was absolutely sound public policy. It was truly a unique response to an unprecedented national tragedy. It was the right thing to do. It was the best in government. It was sound. It was reasonable. Don't ever do it again. Don't ever do a 9/11 fund again. The 9/11 fund, from the perspective of the American people, was something that they wanted to do. They wanted to send a message, not only to the victims, but to the world. We take care of our own. But you should have read some of the emails I received when I was administering the 9/11 fund. Dear Mr. Feinberg, my son died in Oklahoma City. Where's my check? Dear Mr. Feinberg, I don't get it. My wife died in the basement of the World Trade Center in the original 1993 attacks committed by the very same type of people. Where's my money? It wasn't only terrorism. Dear Mr. Feinberg, I don't get it. Last year, my wife, saved 3 little girls from drowning in the Mississippi River, and then she drowned a heroine. Where's my check? You better be careful when you carve out special public compensation for only these people. Everybody else, sorry, fend for yourself. Bad things happen to good people every day in this country, and you don't have a 9/11 fund. So I think it highly unlikely. There was no 9/11 fund after Katrina. There's no 9/11 fund for tornadoes, windstorms, hurricanes, floods, aircraft crashes. No 9/11 fund. Instead, everybody, self-reliance, life insurance. That's the way it is. 9/11. BP. I don't think you'll see BP again. Maybe. $20 billion fronted by BP without a trial, without a finding of liability. Ken, take $20 billion and pay all eligible claims, and we'll worry later on about seeking contribution from co-defendants like Halliburton and Transocean. Pay the people. Pay the people. In 16 months, we spent and paid $6.5 billion and secured 220,000 releases. It worked. Now they're having all sorts of trouble down there. I don't know if you've been following it. I've been following as an interested citizen. I'm long gone. Now they're having trouble with the class settlement. I could understand that. I paid all the legitimate claims. 220,000 in 16 months paid out. Fishermen, shrimpers, oyster harvesters, hotel operators, etc. GM found in its internal investigation 13 deaths attributed to the switch. We're at 33 so far, with still November, December, and January to go. I'm sure it'll be more than triple what GM found. Plus, we've already found about 40, 45 physical injuries attributable to the switch. GM will pay the freight. But you see, these programs are very, very rare. They don't happen. Every day bad things happen. You don't have funds like this. When you talk about unconventional responses, you can put the unconventional responses on one hand or two hands. Mr. Feinberg, is this the wave of the future, these funds? These funds are the wave of nothing. They are precedents for nothing. I'm always somewhat amused at trial lawyers who see these programs that I design and administer as some sort of threat to the conventional tort system. They're not a threat. First of all, the conventional tort system works pretty well in this country. I'm a defender of it. If you walk outside onto Michigan Avenue, God forbid, and get hit by a car, I think the tort system works pretty well. It has flaws, especially when it comes to mass torts. But I think the tort system works pretty well. Trial lawyers don't have anything to fear. Frankly, even if you think the tort system doesn't work so well, tough. What are you going to do about it? Nothing. If you think that tort reform can change the basic system, the adversary system, the time-honored way we resolve litigation, if you think that some reform is going to change that system, you don't know American history the way you should. You're tilting at windmills. The tort system is so ingrained in the fabric of this country, in the history of the country, that any wholesale change, let's go to a Feinberg-type no-fault system, it's not going to happen. Now, there are examples of seminal changes in the way we litigate, But those seminal major changes are very few in history. There are some. The best example of an alternative to the tort system that's been accepted and adopted in 50 states is workers' compensation. Workers' comp is an alternative to the tort system. You don't have to sue. We'll give you a certain amount of money for your harm that you suffered on the job. Now, it's not going to be a pot of gold like you'd get in the tort system, but you don't have to prove anything. You don't have to prove liability. You don't have to prove fault. You have to prove that you got an injury on the job. That's an administrative alternative. There are some. Very few. Very few. Now you know that when you design these systems of compensation, these unique responses to unprecedented tragedies, now you know that the two systems, BP, GM, 9/11, over here, One Fund Boston, Newtown, Connecticut, Virginia Tech, over here, the conceptual designs are very, very different, aren't they? You're paying people in both regimens. Both regimens have a compensation program. But notice over here, if you want to voluntarily attract people out of litigation, you got to pay them. And not only do you have to pay them, but everybody got to get a different amount of money. The stockbroker, the banker, the lawyer, you got to pay that widow or widower a lot more than the waiter, the busboy, the cop, the fireman, the soldier. They made more. It's the tort system. Mrs. Jones, we don't want you to sue. Mr. Smith, we don't want you to sue. All right, I won't sue. What are you going to give me in lieu, in consideration for not suing? My wife was making $5 million a year. What are you going to give me? The waiter's wife says he was making, $12,000 a year. Everybody, if your compensation scheme is joined at the hip of the tort system, everybody's getting different amounts of money. I'm busy calculating different awards to convince people they shouldn't sue. Now, that's very, very different than One Fund Boston or Connecticut or Virginia Tech. Folks, I've got $8 million or $61 million. Doesn't matter. And I'm going to give it out without regard to the tort system. All who died get the same amount. All who lost a limb get the same amount. All who lost 2 limbs get the same amount. All who were if you were in the hospital as a result of the marathon bombings for over 30 days, $950,000. 3 weeks, $750,000. 2 weeks, $500,000. Don't send me hospital records. Don't send me tax returns. Don't send me profit and loss statements. Send me a claim form and one letter attached from the hospital saying how long you were in the hospital because of the bombings and what your injuries were. That's all I want to know. Well, don't you want to see my hospital records? Why? Don't you want to see my medical records? Why? Hospitalization is a pretty good surrogate for seriousness of injury. Just send me how long you were in the hospital. People who have a broken leg aren't in the hospital as long as people who lost a leg. That's all we want to know. One size fits all as to designated classification of injury. It's very simple. You see, these programs that I administer, whether they're tort alternatives or not, thrive on a certain objectives, certain characteristics of these programs. Speed. There's no substitute for getting money out the door fast. Efficiency. Efficiency. The programs are streamlined. They're efficient. There's a small group of people doing the work. There's no bureaucracy. Cost, pro bono, or de minimis. There's no, on the One Fund Boston side, cost on the Tort alternative side is substantial. Got to have people, accountants and claims processors and everything. You see how it works? Speed, efficiency, certainty, certainty. People are uncertain about their lives. They've been victims of horrible tragedy. One thing is certain: compensation. And you know what you're getting. Give me the documents and you'll have it. There's some psychic benefit to this, you see. That's how it works. That's how it works. Now, we could spend a whole seminar on this, a whole semester. But that's how it works. Those are the building blocks. Now, every one of these examples, there are unique problems to that particular compensation program. 9/11. 9/11, the statute said anybody who died can get, the families can get paid. The airplanes, the World Trade Center, the Pentagon. Then the program, the statute said, or anybody who was physically injured in the immediate vicinity of the World Trade, of the terrorist attacks. Well, what does that mean? First of all, physical injury means you can't recover from mental injury. Mr. Feinberg, I escaped from the World Trade Center by dodging flying bodies and stepping over severed limbs and dead people. I went home and I can't get out of bed. I'm so distraught. Do you have a physical injury? No, but I have mental. You're ineligible. The statute says it's got to be a physical injury. Congress didn't want millions of people watching the tragedy from Nebraska filing a claim, claiming mental injury. In a physical injury in the immediate vicinity of the World Trade Center. What's that mean? Mr. Feinberg, I was hanging a picture on East 96th Street, 4 miles from the World Trade Center. I saw the plane hit the building, I fell off a ladder, and I broke my leg. Pay me. No, you're not in the immediate vicinity. It helps to have taken Tort 1 at Catholic. This is all Tort 1 stuff, isn't it? It's all Tort 1. Proximate cause, immediate vicinity. So there are always problems. BP, we received in 16 months 1.2 million claims from 50 states. I got 150 claims from Washington, D.C. I didn't know the oil got up here this far. 150. Massachusetts, 300. New York, 400. California, 400. 35 foreign countries. China, Norway, Sweden. Middle East, Israel. Israel? Build it and they will come. Most are ineligible. Was your damage proximately caused by the oil spill? Dust off your tort book. You know who I have working on these cases? My former students, mass tort students, students that took evidence with me or whatever. They understand the issues. They passed the final exam. It probably will be on the final exam at Catholic. 1 million, volume, you see, that's a problem. So many claims. GM, read the protocol online. Was the defective switch the proximate cause of the accident? Now, if that isn't a tort problem, if that isn't, go to your textbook and the restatement of torts. That's what we're doing every day, 2 miles, 3 miles from here. We're looking at claims. Under the protocol, is it an eligible vehicle? Don't come to me with a Mercedes saying it was a GM ignition switch. Is it an eligible vehicle? Did the airbag deploy at the time of the accident? If the airbag deployed, don't even bother filing, because that means the power was on and the switch wasn't in accessory or off. So if the police report says horrible accident, airbag deployed, it ain't the switch, don't apply. I can't help you. But let's say it is an accident, and there's a death or a physical injury, and the airbag didn't deploy. Now, show me circumstantial evidence of defective switch causing the accident. What does the police report say? What does the black box data in each of these cars, the black box, the computer data, what does that say? What do the photos show? You look at these photographs of these accidents, and the car hits a tree going 60. The engine is practically in the back seat. It's horrible. And the airbag didn't deploy? Pay it. A rollover, side swiped, or rear ender. Well, the airbag shouldn't deploy. So what else do you have? Maintenance records, you're having trouble with the car, the switch, the steering wheel, the lock brake, stalling, insurance investigative reports, contemporary medical records that say something about the cause of the accident and what happened. You build a case through circumstantial inference, evidence at Catholic, inferences and presumptions. Torts at Catholic, proximate cause. There it is. That's what we do. That's what we do. What I want to make a few final points. We'll take some questions, but what I do is not rocket science. There are people in this room, not just here in the front row, there are people in this room that could do exactly what I do. It is not rocket science. I remember torts. I know how to interpret immediate vicinity, and I know what we have to do to get the claims paid. So do you. It isn't, you don't have to be an astrophysicist in this stuff. But if you want to do this work, you better brace yourself, because it is emotional. I'm asked all the time, is your law degree an important value in doing what you do? No. It's a wash. A divinity degree, that would be useful. Or a degree in psychiatry, that would be useful. Because you're dealing here with very, very vulnerable people. And it is very emotional, and it is very chilling. And by far the most difficult aspect of my work is the one-on-one due process that you must afford any claimant who wants to come and see you. It's very important. Not only is it the right thing to do, but it also improves the brand, you see. And it sends a message that we're not heartless bureaucrats with a calculator. We want to hear what anybody wants to tell us about any of these incidents. So brace yourself, because when I meet with a person or a family that lost a loved one, you better have Kleenex on that table, and you better be ready for a very, very horrific, chilling hearing. Nobody comes to talk to me about money. The money is the money. Very, very rare that anybody says, I'm here looking for more money. Whoever comes to see me usually has two purposes in mind. One, to vent about life's unfairness. Mr. Feinberg, I lost my daughter because of GM. There is no justice in this world, Mr. Feinberg. My daughter was an angel. She had, the world was her oyster. She was going to go far. And now she's gone at 17. Like that. Mr. Feinberg, why? Why? There is no God, Mr. Feinberg. No God could allow this to happen. I will never again set foot in a church. I will never again set foot in a synagogue. I want nothing to do after this horror. I don't believe it. I don't believe that God could let this happen. Or, human nature being what it is, Mr. Feinberg, he's in a better place. Jesus will take care of him. He's in a better place. I'll join him someday. One lady told me in 9/11, as a result of the horror, she was going to go to divinity school. As varied as human nature, these hearings. But they are very, very difficult. And you approach the hearing expecting that they'll be difficult. Mr. Feinberg, I lost my husband. He was a fireman at the World Trade Center. And he left me with our 2 children, 6 and 4. Now you're going to give me $2.8 million. I want it in 30 days. 30 days? Why do you want it in 30 days? Why? I'll tell you why. I have terminal cancer. I have 10 weeks to live. My husband was going to survive me and take care of our 2 children. Now they're going to be orphans. I have got to get this money and set up a trust while I have my faculties. I'm not going to be able to focus much longer. We accelerated the money. 8 weeks later, she died. Amazing. And you hear all sorts of stories. And you learn to be a listener and to exhibit a certain empathy, very important, empathy. And be careful what you say. Be careful what you say. You make mistakes all the time and you try and minimize the mistakes. But it's the tough part. I was struck by the fact that I'm asked sometimes in these tragedies, what bothers people more than anything? What one aspect of these tragedies is the most emotionally trying? I must say it is, in so many of these tragedies, at 9/11 particularly, the absence of a body. I'm amazed. People come in and they are distraught. Not only did they lose their husband, their wife, their kids, their sons, their daughters, their brothers, their sisters, but they were incinerated. So there's no body to bury. That sets people off. They get very, very distraught over that. It's an amazing thing, human nature. The other reason people come to see me is not to vent, but to validate the memory of a lost loved one. Mr. Feinberg, I lost my wife at the Pentagon. We were married for 25 years. And I'd like to, at the beginning of this hearing, I'd like to show you a video of my wife and our wedding 25 years ago. I want to show you our wedding, what an angel she was. Mr. Jones, you don't have to show me that video. It'll be very, very emotional, and it won't have any bearing on compensation. You're going to watch. I want you to see what those murderers did to my angel. Play the video. My office in these 9/11 or GM, whatever, filled with memorabilia, ribbons, diplomas, certificates of good conduct, medals, videos, audios, books. Unbelievable. People want to talk to somebody about a death, about an injury. And they do it. And you listen, and you listen, and you empathize, and you try to minimize saying anything or doing anything to very vulnerable people. That's how it works. Now, you can't always give everybody a hearing. In BP, we had 1,200,000 claims. We didn't have time to give everybody a hearing. BP was a different problem. Problem in BP was there were so many people who filed claims without any proof. Mr. Feinberg, I lost $100,000 because they closed the fishing grounds in the Gulf, and I couldn't fish, and I lost 100,000. Okay. Do you have? Show me what proof do you have? Proof? We do things with a handshake down here. Well, that may be, but I can't pay you on a handshake. What proof do you have of 100,000? Do you have tax returns? No. Checkbook, profit and loss statements, trip tickets? Well, here's what I've got. It may be in crayon, but here it is. All right. I've looked at it. Not certain, but all right, we'll give you $100,000. We're going to send you a check for $100,000 in 30 days. Now, with it, we're going to send you a 1099 from the IRS. You're going to send me a 1099? I waive it. You can't waive a 1099. I've got to send you the 1099. You're really going to send that? Yeah, I have to. I withdraw my claim. You mean I'm sending you $100,000 in 30 days and you don't want it? Rip it up. Probably never paid taxes in his life. See, that's how it works. So that's sort of a summary of unconventional responses to unique catastrophes. We could spend an entire year at Catholic focusing on the various aspects of these programs. I think they're aberrations. I think if they're going to be used at all, they should be used very, very, very sparingly. They raise all sorts of political science issues, not only about who gets what, and some people are eligible while other victims are not, but even the programs themselves. You guys are lawyers. You must be troubled by these programs. All of this delegation to one person, no committees, no appeals, no second guessing. Ken will decide. Well, thank you very much, Ken will decide. I don't think that's very sound public policy. But when policymakers decide we want efficient, speedy relief, and we're not going to get it with committees and appeals, let Ken do it. That doesn't sound like, it sounds like sort of a lawless ad hominem system, I must say. I do it because I did the last one and the one before that, and they worked. One of these days I'll fall flat in my face, you'll do it. But the idea that there's no real checks and balances, you see, is a very important reason why we better keep these programs rather rare, especially in cases like BPGM and 9/11 where you're surrendering rights. It's one thing if you screw up with a gift, although that doesn't sit well with the public or the claimant. But it's another thing if you're requiring people to release their rights in return for compensation. That's why those cases are much more provocative, much more difficult to administer. So that's it. That is, I think, giving a 45-minute meaning to unconventional responses. Yes, they're all unconventional. To unique catastrophes. Pretty unique. An oil spill or a 9/11 terrorist attack or a ignition switch failure. Tailoring the law, that's what we do. We tailor the law to meet the challenge of compensation. That's how it works. So, we have, I hope I've done justice to the Brown lecture series. We have a few minutes, and who has questions? Yeah, it always starts this way, but there are going to be some good questions, I'm sure. Yes, sir. You're a graduate of?
The law school from 1970. And I was with the SEC, and my mentor at the SEC was a colleague, I think you know, Stanley Sporkin, who's handled some similarly unique type of things in a slightly different legal area. In my discussion with Sporkin, he said that it was not like being a judge, not like you said it. I mean, it was humanity. why do you think they keep picking you as a lawyer rather than a priest?
I think the reason I've been picked is, as I said, because I did the last one. And I did the one before that, going back to Agent Orange in 1984. And I think policymakers get some comfort in deciding that for this very traumatic, tricky public policy, let's lay it on a guy who's done it before. We'll get credit for picking the guy who did it successfully. We'll insulate ourselves politically. That's one reason. The other reason is I'm not sure that there are that many people out there who visibly are alternatives. There are a lot of people who could do it. Right in this room there are people who could do it if they had to. But when you go down the list of people who could sort of be credible and who would agree to do it, I think that vastly limits the universe as well. Some reasons. Now, I do it because I'm asked. Ken, do you ever say no? You're going to say no to President Obama? Ken, we want you to do the BP oil spill. No, I'm busy. You know? President Bush. Ken, 9/11. I really want you to do this. We have soldiers all over the world risking their lives, and they will, and I want you to do this. Mr. President, I'll do it. By the way, Mr. President, you want me to do 9/11, but let me tell you, you know, I'm the former chief of staff to Senator Ted Kennedy. Are you sure you want me to do this? That's exactly why I want you to do it. This program could be a real debacle. This could be a disaster. If you pull this off, I chose you. If you fail, Kennedy's guy, what do you expect? That's exactly why I want you. So there's some politics in it too. Yes, ma'am.
Yes, a wonderful talk, and it's so great to hear from you and learning so much. But I did want to ask you, you talked about the emotional side of the job, and it's extraordinary, truly extraordinary, but yet there's so many emotional aspects to the practice of law, and I wonder if you think there's something that could have come from your law school education that could have better prepared you for the ordinary practice of law and even for these extraordinary times.
I don't think anything in law school could prepare me for this. When I went to law school in ancient times, there was no ADR program at NYU. There was no mediation or arbitration programs. I think that the part of law school that didn't help me at all in doing these programs was the law school curriculum's commitment to the adversarial system and to trial by battle. And I find that system, which I honor and practice, isn't very, very helpful when you get into these type of situations, which are ameliorative, fiduciary, non-adversarial, supportive. We're in this together, touchy-feely. That adversary system can come back and really haunt you when you're trying to build some emotional attachment between claimants and the program. But you do it by practice. You instinctively, intuitively, you do it. You also never lose the law school and the legal obligation to avoid bias and the perception of bias and fairness and no conflict of interest and detached objectivity if you can. It's not easy, but you try and be professional.
Given your experience, are there any changes to the traditional tort law approach to damages that you would advocate? Perhaps the relentlessly economic approach to wrongful death damages?
Well, I don't know. I mean, I don't think it would make much, even if I did recommend it, I don't think there's much chance it would happen. I think the one area of tort law that I think on damages that is so problematic is pain and suffering. What we do in these funds is we don't try and calculate pain and suffering. We simply say, GM, victim died, economic loss plus $1 million for pain and suffering, and $300,000 for every surviving spouse and dependent. That's it on pain and suffering. One size fits all. We're not going to calibrate. You could never get away with that in the courtroom. I think it's very, very helpful that you don't try and be Solomon in determining different amounts of pain and suffering. Everybody suffered. I think we've done that. Yes, ma'am. How much time do I spend on the compensation system? 100% if I have one. Now, Agent Orange, 1984, 9/11, 2001 to 3, BP 2009 to 11, GM 2013. So I have in the past spent time doing mediations and arbitrations, my ADR practice. But once you get involved in one of these mega cases with all that is needed to be done, it sort of occupies all your time. Now, I have a law firm with just me and my partner in New York, so we subcontract out everything. Claims companies, accounting firms, lawyers, anti-fraud companies to protect against fraud. We economic modeling, lexicon, or companies like that to help us develop the methodologies for calculating damages. So, I mean, we subcontract out everything. I have no overhead, no personal overhead, no firm overhead. It's all RFP. What do you guys want? We're interested. You have this skill. You have this discipline. You have this expertise. We're interested. One more? Anybody? Before we close, let me just say, this means a great deal to me, this Brown lecture. I try to do the best I can as a lawyer here in town to stay active and visit the different law schools and teach and lecture and visit. This is a great school. Hard to get here, but it's a great school, especially rush hour. It's a great school. This is a very credible, superb lecture series honoring Brown. And I want to thank the Dean and David for bestowing this. I mean, this is really an honor for me to be here today with you guys. And I hope that you understand better now what it is I do, why I do it, when we do it, and what it means to our whole system of laws in this country. So thank you very much.
I can assure you they don't clap this much for me. Mr. Feinberg, we have a small token of our appreciation. It's a pen set with the Catholic University logo on it. We hope you will display it.
I will.
Appropriately with all the other gifts that come your way in your offices. Thank you very much for joining us today.
Thank you.
We really appreciate it.
Thank you.
Hope you can. Those of you who can stay, we'll have a reception right now out in the apron. Please join us outside.